Act 3 presents the government's witnesses. Each one will be examined by a prosecution attorney, followed with a cross-examination by one of the defense attorneys. On rare occasions, the prosecution may redirect questions following the defense's cross. Introducing Defense Attorney Russell Rosenthal. Russell Rosenthal received his Juris Doctor from the University of Florida Law School in 1980. Mr. Rosenthal has been an assistant federal defender in Fort Myers since 2002 and has been the division supervisor of the Fort Myers office since July 2019. He has also served as an assistant federal defender in the Middle District of Florida for 19 years. Mr. Murray will conduct the first witness examination for the government. Mr. Rosenthal will cross-examine for the defense.
In response to questioning by Mr. Murray, Mr. Howland provided the following information about himself. At the time of the trial, he was employed by the U.S. Attorney's Office and had been for a little over a year. He had previously worked for the Florida Office of Financial Regulation and had attended Florida State, where he studied criminology. He attended a 2-week course at the Federal Law Enforcement Academy, as well as numerous investment fraud trainings elsewhere. He performed financial analysis and testified that he became familiar with Mike DaCorta's companies in 2018 when the Commodity Futures Trading Commission, the CFTC, referred a case to the FBI, which in turn referred the case to his office, where he was assigned to assist with financial analysis. Mr. Howland received copies of bank accounts, spreadsheets, corporate documents, and a record of Mike DaCorta's relationship with the NFA. There were no records provided by the CFTC about any other living, breathing persons. Mr. Murray showed documents concerning the incorporation of Oasis Management, OM, for which Mike was the registered agent. Through an exhausting presentation of documents ranging from change of corporate name filings to bank records and signature cards, Mr. Howland testified that Mr. DaCorta had signed a variety of documents on behalf of OM as its president. Mr. Murray repeated his performance with documents related to Oasis International Group, OIG, and Mr. Howland again testified that Mr. DaCorta had signed them in his capacity as an officer of that company. In all, Mr. Howland was asked to testify that Mr. DaCorta was an officer or registered agent for Oasis Management LLC, Oasis International Group Ltd., Oasis Global FX Ltd., and Oasis Global Belize SA. He was also asked to verify that his examination had reviewed records for 16 limited liability companies, LLCs, including 11 properties and 2 businesses owned by one of the Oasis companies and 3 companies controlled by Joe Annealy. He was shown the articles of incorporation for each LLC and asked to identify who the registered agent and managing member was for each. A table of his responses is hereafter provided. This table shows the exhibits entered by Mr. Murray during Mr. Howland's testimony.
As you saw on the previous slide, the government admitted 52 exhibits into the trial record to use during Mr. Howland's testimony. Nearly all of them related to Oasis properties registered in Florida as limited liability companies, LLCs. There does not appear to be any significance to these exhibits. They are irrelevant to the charges brought against the defendant, Mr. DaCorta. Mr. Murray spent more than half an hour presenting one document after another to Mr. Howland and the jury, but made no point other than that Mr. DaCorta was most frequently listed as the registered agent for the company-owned LLCs. So, what is a registered agent, and do limited liability companies need one?
When a limited liability company or corporation is formed, it is required to list a registered agent with the Secretary of State's office. A registered agent is a person or entity appointed to handle necessary government, tax, and legal correspondence about the business. The main purpose of a registered agent is to ensure that the business receives essential and time-sensitive information. If the business is sued or subpoenaed, the opposing party will send notices to the registered agent listed in the business's public records with the state. A reliable registered agent will immediately report to the business owners when documents arrive, giving them as much time as possible to respond. Without a registered agent, important correspondence can be lost in the shuffle of other business mail, causing a business owner or CEO to miss deadlines and suffer legal and financial consequences. The agent must be located in the same state as the business, is required to list a physical address, not a P.O. box, and be physically present at this location during standard business hours. Here follows a few samples of the kind of documents Mr. Murray presented to the jury during his examination of Mr. Howland. We won't bore you with all 52 of them, as they are each quite similar and similarly irrelevant. Exhibit 1A is the Articles of Organization for Oasis Management, filed November 7, 2011. The Articles of Organization for Oasis Management show that the company was registered in Wyoming. Corp 95, with offices in that state, served as its registered agent. Exhibit 1C showed that the 2018 LLC annual report to the Wyoming Secretary of State reflected a change of the company's registered agent to Vista Management Services, Inc. in Rawlins, Wyoming. Exhibit 5A showed the certificate of incumbency for Oasis International Group Limited, registered in the Cayman Islands and having 3 directors, Joseph S. Annealy, Michael DaCorta, and Raymond Monti. The date of their appointments was March 1, 2013, and each was given 2,700,000 ordinary shares in the company. What significance this document or any of the others had to the prosecution of the case was not explained. Finally, we offer an example of one of the standalone properties purchased by Oasis in expectation of it increasing in value over time. In all, there were 11 of such investment properties owned by Oasis. Exhibit 15 is a copy of the Articles of Organization for 444 Gulf of Mexico LLC, dated October 30, 2017, and indicating that Michael DaCorta was the initial registered agent for 444 Gulf of Mexico LLC, Oasis's office building. Of the 6 pages in this document, only this, page 3, was shown to Mr. Howland and the jury. Deeper into Exhibit 15 on page 4, it is revealed that Mr. Annealy replaced Mr. DaCorta as registered agent for 444 Gulf of Mexico LLC on February 21, 2018. This page was not shown to the jury. Still in Exhibit 15 on page 6, the final page of the document, which was also kept from the jury, we find that Mr. DaCorta replaced Mr. Annealy as registered agent for this property on March 20, 2019. The person who filed this report with Florida's Secretary of State is not identified. This table summarizes the information shown to the jury through the display of 16 very dry exhibits. As you will see, it does not present the mysteriously unexplained full story about the shifting of registered agents for these LLCs. Mr. Murray only showed the original agent for each one and in some, but not all cases, their managing company. The timely point could have been made that the investment properties were all owned by either Oasis Management or Oasis International Group, and represented part of the company's investment strategy, a point that should have been made by defense counsel Rosenthal on cross-examination, but wasn't. Mr. Murray glossed over any discussion of Exhibit 55 for Bowling Green Capital, mentioning only that the company was formed in New York State on April 6, 2007 with Joseph Annealy as registered agent, but nothing about the fact that it was privately owned by him or that it was created 4 years before Oasis Management came into existence. Similarly, Mr. Murray glossed over Exhibit 65 for Four Oaks, merely pointing out that the company was formed on January 7, 2019, and that Mr. Annealy was its registered agent. Mr. Howland testified that he received financial records for Bowling Green, Lagoon Investments, and Four Oaks, but he did not say that he reviewed them. He also testified that he recognized and reviewed the Capital One bank account for Bowling Green, the Regions One account records for Lagoon Investments, and the Wells Fargo bank accounts for Four Oaks, but offered no conclusion about them. To Mr. Murray's question, "They contain accurate information relating to the bank records that you received as part of this investigation?" He answered yes, but he didn't qualify what that accurate information was. It could have been just the company addresses for all the jury could deduce from his testimony. Mr. Howland continued to answer yes to questions about whether he had received and analyzed records related to Satellite Holdings, another defendant in the civil case, and personal financial records of Michael DaCorta. He acknowledged that he had reviewed Mr. DaCorta's Wells Fargo bank records as well as documents related to Sergio DaCorta, Michael DaCorta's father. Without testifying to any conclusions he may have drawn from the documents he reviewed, when asked what he did after analyzing the bank records just discussed, he replied, I shared them with the investigative team.
Blah, 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 blah.
Mr. Howland, generally speaking, what did those records show?
It showed outflows and inflows from these accounts.
What was the sum of those, of the money that you analyzed in terms of the inflows?
Over $77 million.
Mr. Murray's first witness examination consumed more than 30 minutes, but consisted of nothing more than a very boring and repetitious presentation of county property registration documents, exhibit numbers and financial records, without benefit of any conclusion being drawn about them. It beggars the imagination to ponder what the prosecution was trying to accomplish in questioning Mr. Howland, other than to leave some kind of damaging impression on the jury. A more comprehensive examination of the filing records shows that on February 21, 2018, someone, most likely Mr. Annealy, changed the registered agent for most of the properties from Mr. DaCorta to Mr. Annealy. Then on March 20, 2019, just 3 weeks before those assets were seized by the government, the agent was changed back to Mr. DaCorta. Why? What was happening during this period of time that Mr. DaCorta was not being notified about, but Mr. Annealy may have been?
Initially, most of Oasis's LLCs were filed with Mike DaCorta as registered agent. Mr. Annealy lived at one of the Founders Club Drive addresses. The other was an empty lot abutting his residence. Mr. Annealy created Bowling Green 4 years before Oasis Management was formed. Unlike the other LLCs, it was not owned by or under the control of Oasis. After gaining control of Oasis's financial flows, Mr. Annealy directed money embezzled from Oasis into Bowling Green Capital for his and his wife's personal use. Lagoon Investments was never used. Roar of the Lion opened with U.S. corporation agents as its registered agent, but they were replaced in late 2017 by Mike DaCorta. On February 21, 2018, new filings were made with Florida's Secretary of State to switch the registered agent for standalone property LLCs from Mike DaCorta to Joseph Annealy. The 4 condominiums and Roar of the Lion Fitness remained under Mr. DaCorta's agency. On March 20, 2019, just 3 weeks and 2 business days before the original case was opened against Oasis, another update was filed with Florida's Secretary of State that switched the previously changed registered agent for Oasis's LLCs back to Mike DaCorta. 4 Oaks and Bowling Green Capital always remained under the control of Joseph Annealy. Between February 21, 2018 and March 20, 2019, any notice of legal activity affecting most of Oasis's LLCs would have been directed to Joseph Annealy, not Mike DaCorta. During that period, Mr. DaCorta would not have received notice of any government, tax, or legal correspondence about those Oasis-owned properties which might otherwise have forewarned him of impending trouble for his companies.
You know, I think they were trying to make a point with that sketch.
What's the point?
You're right. Forget it.
Mr. Howland, you testified about a number of different properties, correct?
Correct.
And these properties are all held by individual LLCs or limited liability corporations, correct?
Correct.
And you testified as to each of these companies having a particular resident agent.
Correct.
A resident agent is required of every corporation in Florida or every company in Florida, correct?
Correct.
You have to have somebody to serve papers on, correct?
Correct.
It has nothing to do with the ownership of the company?
Correct.
You talked about there was a total of $77 million?
Correct.
Now, there are occasions where funds were transferred from Oasis Management to, or Oasis International to one of the LLCs, correct?
Correct.
So, Basically, that would be reflected as a deposit going into Oasis Management, for example, and then a deposit from there going into one of the LLCs, correct?
Correct.
Thank you.
Why, a 4-year-old child could understand this report. Run out and find me a 4-year-old child. I can't make head or tail out of it.
During his cross-examination of Mr. Howland, Mr. Rosenthal made no comment about the fact that all the investment property LLCs were owned by either Oasis Management or Oasis International Group, or that Four Oaks was created a mere 4 months before Oasis was shut down, and that the defendant, Michael DaCorta, had no connection to or control over it. Neither did he mention that Lagoon Investments, Exhibit 60, was never employed for use by Oasis.
Mr. Rosenthal offered nothing to help the jury understand anything that Mr. Howland had testified to, or to clarify for them that the witness's testimony was entirely irrelevant to the charges against his client. Whatever impression the prosecution hoped to make upon the jury was left entirely unblemished by the defense attorney's 2-minute cross-examination.
Terrible! Awful! I hated it!